Hello and welcome to Edukemy's YouTube channel. My name is Harsh Singh and in this video, we shall discuss the featured news for 11th November 2021. The featured news for today is on a very hot topic these days, UAPA, Unlawful Activities Prevention Act. The government has been using this act so that it can bar certain kind of people and call them terrorists, right, and put them under behind the bars. But there has been a resistance to this kind of activities from the government. So sorry. So in this slide, we will understand various perspectives. What is the perspective of the government? What is the perspective of civil liberties? And what is the perspective of judiciary? Right? There have been a various number of opinions which have been indicated. And the latest one, the latest incident is the government booking social media account holders of more than 102 accounts in Tripura. So because it was alleged that they were spreading communal disharmony in Tripura because of certain recent issues in the state, right? So this was what was alleged in Tripura. Then there was another case that was in Delhi, right? During Delhi riots, certain people were booked under UAPA again. Now, while they were only against the opinions of the government, they had difference of opinion with the government or the state. They had dissenting point of views. They were booked as a terrorist under Unlawful Activities Prevention Act. They might have indulged in acts of vandalism. That means they might have burned the buses, government buses, but they were booked as terrorists, right? So this is where we have to understand what is the difference between various acts, right? UAPA is an act, Unlawful Activities Prevention Act is an act which ideally needs to be used during times of extremities. But the government has started to use this. In fact, the report says that around 30% plus usage of the act has happened after 2015-16, and more than 70% of the people have been put behind bars because of this act in the last 3 years. So this indicates that there has been an increase in the number of incidences government has used this act, and this is why it becomes important why the government is using this act in a number of cases and what are the other perspectives involved. Okay, good evening to Netra, good evening Jayashree, hello Sam. All right, so in one of the cases what happened was radical literature. I have discussed this in one of the featured news, but I want to share this again. This becomes important. So radical literature being found at one's home, or some book related to caste issues, right? So something that could be controversial, right? Leaflets related to Maoist organizations or dissent notes, right? Notes of Lenin times. These were found with certain people. Now, do these form the ground of committing a terrorist activity? No, they do not. However, people were booked under terrorist UAPA Act itself as terrorists. And when people are booked under this act is a little stringent in many ways. First of all, it designates the person as terrorist. So this is a social stigma. Then to be able to get bail is one thing that is very, very tough in this particular act. And then there is also a way in which Supreme Court needs to look at this case. The way objectively, if the Supreme Court looks at this case, the act is designed in a way not to give bail or any kind of respite to the accused, right? The accused cannot even present their case. This is the kind of act we are talking of. Now, in light of this, if you look at the civil liberties of the individual, the fundamental rights of the individual, they are curtailed completely. So this is where the opinion of civil liberties comes, and Supreme Court jurisdiction and wider interpretation of the law also comes in. So we will quickly discuss both of them and then hop on to the featured news that is also centered around exactly the same thing. Now, firstly, the United Nations does not declare a terrorist act of this sort, right, where a person is intellectually inclined or ideologically inclined towards a particular entity, a particular idea. This is not a terrorist act. Terrorist act is one where the person is ensuring that they are getting involved to harm somebody. They are going to harm somebody or they have harmed somebody. This is one. The second one is related to they're committing certain kind of violence. So these are certain important ingredients under which a terrorist activity will be accounted for according to United Nations. Also, the terrorist activity or terrorist person, they have to ensure that they are arm twisting the government in doing something or not doing something. They are increasing the amount of fear present in the common sphere. So these are essential ingredients of terrorism. But if a person is only indulged in same ideology as Maoists, for example leftist ideology, do they need to be behind bars as terrorists? Not sure, not sure. They only resonate with the opinions, that is all. And there are times when if the opinion is not as that of the government uses these kind of acts and puts those persons behind bars, right? So as Amlan says, sometimes these are political news from Tripura, right? Sam rightly points out that conviction rate is very less. It is hardly 2% in the last 3 years, 2016 to 19, hardly 2% conviction rate. That means there are places where there are loopholes. That is why conviction is not happening. That is why the person who has filed the charge sheet against the accused, the person is getting bail or later released. Now, it means that the case that was earlier filed, that was not with the right intent, maybe that there were not sufficient proof found, and that is why the court granted bail later. But the process of granting bail is also very, very tedious. So in the initial go, the court will not listen to the accused. Court has to ideally listen only to the police verdict, and then court will sentence the person to be inside the jail and be under trial, and they will not get bail. This is one of the reasons why around 70 to 80% people who are in jails are under trials. 70 to 80% people in jail are already under trials. They have not been given the punishment. They have only been considered as accused. It has not been sentenced by the court. And many of these people languish a painful life in jail. There are around 4.5 lakh people who are in jail, and many of them have not even gotten the sentence, but they are still in the jail, right? So in this particular act, for 180 days, the person can be kept behind bars and no charge sheet needs to be filed. A charge sheet is the complete document which is filed in which the accusation is there, what IPC and what CRPC, what have been the violations, and it is filed with the court, and then the court also starts to listen to the arguments, right? So 180 days and no charge sheet up till then can be, one need not file the charge sheet. So this is a very long period under which the person will have to be behind the bars. So this is not a very good, very healthy trend, right? No, so this is where the article points out that the judiciary must get activated. So judiciary can interpret this in a very narrow sense. That means the way police wants it to interpret it, or a wider sense where the civil liberties of the individual also prevails, where the judiciary prima facie, if it sees that the person has not committed the crime, it can grant them bail with certain restrictions, right? So this is what we have covered in the featured news today, right? So primarily, two important statistics that you should know is that 33% increase in cases filed in the last 3 years and around 70% increase in the number of arrests. You see, so you need not write 33% and 72. You can just say 30, around 30 and around 70%, right? 2/3, 1/3. These are the kind of easygoing data that you should be using, right? So this is by NCRB, National Crime Records Bureau. These are the kind of data you should keep with yourself so that you can use them when the time is right in the examination or with people. So what did I say? What is the conviction rate? Yeah, Sam said it is 2%. Along with that, the number of people who have been increased number of people who have been kept behind bars is 70%, and around 30% increase in the number of these kind of cases in the last 3 years, right? So these are important parts of it. Along with that, the bail provisions are tough. There this kind of act does not allow dissent. In case, now look at the person who is only a friend of a person who is a Maoist. Now, if a friend, or say suppose a family person, right, mother itself, if the mother is only going to feed her son, does she support terrorism? Does she support Maoism? No, it is not necessary, but it is at the discretion of government to charge them also under this particular act, right? So that is why definition of terrorism, it must be defined in a very, very strict fashion and not an ambiguous manner. So in India, when terrorism is defined, committing any act against the government, all those also qualify as terrorism in this act, right? So if vandalism is done, why are you designating that person as terrorist? It can be covered under various other acts, right? For example, Public Property Vandalism Act. There is an act of similar kind. So put them under this act and not under terrorist act like UAPA. This is important contention. This also gives discretionary power to the government. If anybody goes against the government, these kind of act will be, they will be enabled by the government, and this also bypasses fundamental rights. When we speak of being the largest democracy, we should have people's at the center of it, right? Not the government at the center of it. So it bypasses people's right, right? Now, the article then goes on to say that there is less space for judicial discretion, because the act itself mentions that the police should be heard prima facie. The police story must be heard by judiciary, and that is how the government should ensure that bail is not granted. But there are certain jurisdictions, for example, Twaha Faisal versus Union of India case, where the court has said that mere association with a terrorist organization of member does not attract an offense under UAPA. So this is a very good precedent, but there have been contradictory judgments also. Another judgment has said that a narrow opinion towards this has been given. That means that only the procedure that has been established, that will be followed, right? Only the procedure, that is to put them under bars, behind bars, and not give them bail, right? So the main idea should be to give people their space, right? It should not be treated, the law should not be treated mechanically, but organically, giving people their space. This is a special kind of act to be used only during special situations. And of course, this act, you will not go against this act, because we as people who want to get into the government, we cannot go against this kind of act, but we should talk about important amendments. For example, using them sparingly, only when required. This is one. Then the act should be used as an act which is desirable for a good change in society, does not lead to a bad change. For example, curtailing of fundamental rights, but it could lead to removal of a terrorist. Yes, so use them in the positive light. For a country which is dealing with volatile security situation, see, but a balance must be there while the government uses it with the care. So this is how you can end this article, right? Now, if you look at this complete article, there are various opinions to UAPA, right? UAPA at the center of it, there are certain data statistics that we studied today, 3 of them, right? 70%, 30%, 2%. Remember them, NCRB, right? NCRB is important. Why? The data that you provide becomes credible when you use the word NCRB. Second, we understood a couple of cases where the government has used these and people were later, declared as free. Then we understood what are the issues. For example, definition of terrorism, United Nations definition, India definition, the provision of bail, right? What about fundamental rights? What about procedures? These are all favoring the state and not the individual. So after that, we come to what are the important changes that should be done. Just opposite of this, defining terrorism, then using fundamental rights of the individual, curing them as well. Bail provisions should be relaxed. So these are the kind of recommendations, and towards the end, you will conclude with a statement with the vision, with some, foresight, something that is towards wisdom, right? So this is how you will finish this complete understanding about this article whenever a question is asked, right? So we have not put a question down here, but let me ask you a question here, and you can later on solve this in your mind and later in your answer. The question is, discuss the controversial provisions of UAPA. Discuss the controversial provisions of UAPA. What are the amendments that are proposed so that UAPA becomes friendlier to the civil liberties of Indian nationals? So these are the two components of question. A question in UPSC usually has two components, and therefore you need to serve this answer in a way that both the parts are served well, right? They are balanced, right? So Amlan says that ideological differences does not make a person terrorist. Absolutely, this is what the Supreme Court also says. Now these issues have come to light only after these kind of arrests and certain blatant use of UAPA. Sam says journalists are in the edge of this law. Absolutely. See, this is what has happened in Tripura, and comment on country and comment on government is different. Yes, absolutely. So there is a difference between the the provision of a state, what is the state and what is the government. Government is formed because of the people, but state is more than government. State is constituent of government, it is constituent of people, it is constituent of judiciary, it is constituent of other bodies like the legislature that has parliament, civil society organizations, all of them, right? But government is a small component of it. It cannot define people as specific or not as specific, but it is doing so, right? It is doing so. Sometimes it does so to preserve the state. Sometimes it does so to preserve the state, but sometimes it does it in its own interest. So these are the kind of parochial, narrow interests which should be curtailed, and we should balance the answer, right? So not to criticize the government, but to criticize in a very constructive manner. That becomes very important, right? So this is where our feature discussion comes to a conclusion. I would like you to like this initiative if you like what you are doing, and we will meet tomorrow evening. Tomorrow evening, that is a Friday, tomorrow evening at 6 o'clock for the Gazette and current affairs discussion, and at 6:45 for the feature news discussion. Till then, keep preparing notes, take care of yourself. Thank you for watching.